trying to get
You go
myself
first.
warm.
I think I go, do I go?
Yeah.
May it please the court, counsel. My name is Dave Lowry. I represent Mr. Horak in this appeal.
Would you like to reserve some time?
I don't know that I'm going to use my whole time anyway, but I would reserve, I think I'll reserve 3 minutes or so.
That's
if I
fine.
go that
Thank
long.
you.
Initially, I will state that fortunately or unfortunately, I did not represent Mr. Horak in the underlying case. There are several assignments there which I felt were appropriate, and as counsel correctly points out, they were not raised through the objection process at the domestic relations court. You know, I acknowledge that those particular issues, the test would be plain error. And it's unfortunate that I have to, quite frankly, incur that standard because I think many of them have merit. And it's, I guess I would just proffer my statement by the fact that I understand that the burden of plain error, and I would indicate to the court that the principal issue that I want to address here today, because quite frankly I'm somewhat confused by it, not only the 9th District but the other cases, and that's this concept of imputing income and or finding someone voluntarily underemployed in the process in order to establish child support and or spousal support. The principal issues that are raised involve that, specifically that the court did find that Mr. Horak was voluntarily underemployed and thereafter imputed an amount of income. I think that both of those decisions were wrong. I think that that he was not voluntarily underemployed, but I also feel that the number that was generated, $75,000 a year, was inappropriate based upon the evidence that was presented. In terms of the first aspect of voluntary underemployment, there are some cases and some guidance from this court, and some of them are relatively new. The Missler case, which was determined in 2009. The Collins case, which was actually a 2011 case out of Wayne County. The Hahn case, which was a 2012 case. All those deal with the issue, but the issue in those cases is a little bit different here. Now, I acknowledge that, well, I mean, initially the burden is on the party alleging voluntary underemployment in order to establish the voluntary underemployment, which means in this case, Mrs. Horak would have been the one to determine that, or to bear that burden. I understand that the statute and the case law suggests that it has to be voluntary. There doesn't have to be any spite, ill will, or hatred, or any malice in the notion of voluntary underemployment. But when you apply the facts to this case, and the reason I think that makes this case a little bit more interesting than the ones that I just mentioned in the other case law that goes towards this point, is that what the decision of our trial court stands for, in my opinion, is the fact that people are not free to seek out their own destiny. In other words, they're not free to try to be an entrepreneur, to try to develop their own business, and if they do, they're saddled with this notion that because you tried to become an entrepreneur or start your own business, we're going to penalize you when we find that you're voluntarily underemployed and we impute income at an unreasonable number. And with that said, to apply that to the facts of this case, and this case is different than the ones that I've cited to you. The only case that is somewhat analogous to this case would be the Knopf decision, K-N-O-U-F-F, which is a 2010 Ohio 4063. And this court in that decision endorsed the concept that parents who are subject to support orders are as free as those who are not to adjust their employment to conform to their opportunities and to their disadvantages as well. However, they may not use their separation or divorce to avoid their responsibilities, and their children should not suffer from the needs that would have been met by the parents had the marriage not ended or separation not ensued. And that's at paragraph 38 of the paragraph 30 of the Knopf decision. So this court in the past seems to have said that, listen, people are free to do what they want. If you want to be an entrepreneur, if you want to start your own business, you can do that. But you can't use it to circumvent or to create a situation, and the court specifically reversed, they may not use their separation or divorce to avoid the responsibilities. And that's not the case here. Mr. Horak worked for a place for about a year and a half where his income was roughly $75,000 a year. In 2011, in mid to early 2011, he determines that he wants to start his own business. And the record is replete with why. I mean, the market for these restored cars, he did these restored muscle cars at the time. But the testimony in the record is replete with why. The market was going down, he was working too hard, he had some health injuries. He and his wife discussed him starting a new business. At the time they were doing that, from all evidence that I could read in the record, the marriage was, there was no indication that the parties were going to get a divorce. There was no indication that there was going to be a separation. There was no indication that the marriage was going to end. In 2012, he leaves the place, this Frankie and Dillon's that he was working at. In 2011, he goes out on his own with this Horak's Restoration Company. In 2012, March 12, 2012, the Articles of Organization for the new company are filed. Okay? On that same day, interestingly, that's the day his wife leaves the house with the children. Now, there's issues about how they left, but what seems to be apparent is that husband at some point found out that wife was having an affair with one of her co-workers or someone at work. Okay? The point is at the time Mr. Horak started his business, at the time he left Frankie and Dillon, and at the time the company was set up, the only thing that, there's no indication that he knew, suggested, or perceived that the marriage was not going to continue, and that the parties would continue on with him running his own business, which was necessitated by his health condition, as well as his desire to work for himself and to spend more time with the children, which he alludes to in the transcript of the case. Now, there's some testimony, and mom or wife comes back and says, well, I didn't agree to it. I told him not to quit because he was making too much money. I mean, when I went out on my own, I heard the same thing. You know, you have a job. Why are you doing that? Why are you starting your business? My response is because I want to work for myself. I want to be my own. I want to have my own thing. And that's what Mr. Horak elected to do, and that's what he wanted to do.
But doesn't this, as many of the cases that we hear, come down to the fact that both husband and wife testified before the court, and the court had to determine whom it believed?
It does come to a determination, and that's what I say makes this case interesting, is what this court, I think, is presented with, not necessarily is who to believe, but the issue of whether you are voluntarily underemployed if you elect to work for yourself, okay, or start your own business at a time when there's no indicia that the marriage is going to end, that there was anything wrong. I mean, the case is, there's one case, there's a little snippet in a decision involving a doctor but there's no case law really to that point. And what the law, or what the Ninth District, and that's what I think is the interesting issue here, is that what the law seems to suggest, or what I guess counsel argues, is that it doesn't matter. In some respects it doesn't, but if someone elects to do that, okay, you leave a job. You leave a job thinking that it's okay to leave the job, you want to start your own business. A year later, or 9 months or a year later, you go through you find out something's going on, there's a divorce, and all of a sudden I'm put in a position where you're going to impute income to me from 9 months ago because I made a decision 9 months ago to work for myself, and you objected, you complained about it like any normal human being would, but I'm going to be saddled now with the income level I was making 9 months ago because I elected to become something that I wasn't?
What occurred to me to that point, and also to the point about the court making credibility determinations, was the references in the briefs and wife's brief about how income was reported and what aspects of, payment was made by, bartering and cash was being, put into a safe deposit box or those kinds of things. So I appreciate the position that you take about, are people being hamstrung, who want to strike out on their own? Are we making some broad, proclamation that you have to, be in involuntary servitude, sort of? But aren't there some other aspects in the record before us that the trial court may have taken into consideration?
Well, they may have, but they didn't say that. The court specifically went back to 2010 and said he made $75,000 in 2010. They didn't look at the fact in 2011 he only made $41,000, and they didn't look at the fact that in 2009 he only made $51,000.
So you're saying the trial court didn't consider the fact that there was the allegation he really wasn't reporting on?
There's nothing in the magistrate's decision, there's nothing in the order that suggests that. The court went right back, they honed in on the 2010 75,479 number and the so-called $1,500 a month, which was illusory in and of itself because in 2011 he only made $41,000, and that's a joint tax return filed by the parties, as I understand it. And then in 2012 and 2013 he starts to work for himself, and if you take a look at the Mislay case, this court said the court determines it wouldn't be equitable to impute income to father for the full amount he earned when his business was successful because of time necessary to develop a successful business. So this court acknowledges in its decisions that when you start a business, it takes a while to set up a business and get started. So the underlying court didn't address this issue of where the money was coming from. It honed in on that $75,000, which, like I say, the year before was $51,000, and they had always filed a joint tax return. So I assume that the defendant acquiesced and understood those numbers. So
you're actually in your 3 minutes.
Okay. I guess, you know what? Hey, you know what? It's like my wife. You won't shut up, is what she told me. Thank you.
It happens all the time.
Okay. Good morning. My name is Terrence Scanlon, and I represent Sarah Decker, Horak. I'm really moved by that argument about being shackled forever. Someone once described a child as a 20-year parental emergency. Having raised 3, I'd say 30 years. And I'm one of those who did go out on my own. But the problem is, you've got kids. And Mr. Horak has 2 children. And
so you're saying it is involuntary servitude if you have children, that you can't strike out
I think
on your
that
own?
having the children is, before the court even gets there, I love them, and they turned out well.
You're very blessed then.
But that I think that's the issue, is the children's best interest. And there is the ability to go back into the same line of work. In fact, he did, since these proceedings have ended, he did for a while before he had his back surgery, and was making good money, $1,500 a week.
So I understand your argument. You're saying if you leave an employer where you're making a certain amount of money and you start your own business, and there's no allegation at that point that you're doing it to somehow rob your children or your wife of spousal support or child support, that once a divorce does occur, be it 9 months or 9 years, let's say, if the children are young enough, that the court can still impute income, saying you could have stayed at a different employer and earned more money.
Well, that's a difficult hypothetical. But
Isn't that really what happened here?
Well, he was only out he had quit his job at Frankie and Dillon's in early 2011, so he was only working
few months, and started his business in, I believe, March of 2012. I would say that the fact of the matter is that whether he's self-employed or employed, he has children, and they have needs, and a court must consider the child's best interest. There is no requirement in the law that the decision to become self-employed be motivated by any intent to avoid child support obligations. So the option, the other thing that bothers me, frankly, is that there was a lot of testimony from Jason saying that the bottom just fell out of the restoration business. And he's alluding to the time period following 2007, 2008, which we probably all remember as a time of severe economic restriction, not chaos, but difficulty. And it just strikes me as odd that he would leave an employer who does all kinds of automotive work, including restoration, to start his own business focusing on custom restoration. But it's so bad. It doesn't make sense. The other thing that bothered, this is one of the most difficult transcripts I have ever dealt with, because I could not, frankly, I could not follow the details, but the cash transactions, it's just hard to figure out the financial situation, even currently, of Mr. Horak.
So are you suggesting, again, you're saying that the law doesn't require that you intend to, get out of child support or spousal support or anything, or child support here. It's not that the law, it requires you to be attempting to get out of child support. But yet, you seem to still be suggesting that he was trying to get out of child support by making, or either he was just making a very poor decision.
Yeah, I don't think he was. I don't think that that's true. I think he loved his girls. And
So should you be penalized because you're just making
he's
poor
not,
decisions?
but I don't see it as a penalty. He had an obligation before. A business decision doesn't preempt fatherhood. And,
Oh, I said that incorrectly, perhaps. What I'm meaning is, you're going to have more money obviously imputed to you that may necessitate you getting a different job.
Yeah. Get back.
Because you made a poor decision.
Yeah. I really, unless you have further questions, I would ask the court to affirm this decision.
I'm a little confused over these cars.
Pardon?
These cars are a little confusing too.
They are.
Because obviously, at least the shell was purchased prior to the marriage, and
Yes.
then they were added onto and restored and everything during the marriage, and we're treating them almost like real estate, an appreciation and so forth.
He added to the value of those cars, and our position is it's during the marriage. In fact, he was still working on for one in 2009. That is the difficulty I had in reviewing the transcript, is that I think on one car, $26,000 was paid for car and parts, and he talks about a truckload of parts, enough for 6 or 7 cars. And then he goes and titles one of the two cars, I think for face value was $2,000. And Sarah had testified that, she was living in what later became the marital residence when the cars were bought. The condition of them, they were not restored, they were mere shells. And I think there's not a lot of dispute on that. I think Jason then backpedals a little bit on, well, we put a low value on it when we had them titled in 2005, so we wouldn't pay taxes or some such thing. But the condition of the car, according to Sarah's testimony, is that they were just shells before the marriage. And she was living there at that time before the marriage. And that the work he did during the marriage. So I think it was fair for the court to determine that this was marital property's appreciation and value.
As to the tax refund, the issue of the tax refund.
Yes.
That wife received, and I think it's her position that she used it for matters for the children and for the home, because husband was delinquent in his child support.
Yes, not as retaliation, out of need.
But to that point, was it appropriate for the trial court to not credit him with half of that? It appears as if he wasn't given any credit.
Well, he was $23,000 in arrears, so maybe that was the math that was worked out. Sarah informs me that she's still not getting a lot of money right now for child support, so.
So you're saying it may have been credited if you do the math,
Yes.
and the court's final order, even though it may not have specifically said
Yes.
so. Well, thank you, Kelly.
Thank you.
Thank
Wait, a minute and a half left?
you. You have 2.5 minutes.
Oh boy. I did raise an assignment of error on that issue of credit, and they were not credited. And that was one of my assignments, is the fact that you're going to construe it as if you're going to construe it as a fund that was due to him, and if you're going to justify it based upon there hasn't been a payment of child support, it is clearly punitive if the court doesn't give you credit for it. He was entitled to credit on that. The other one they did on with it was a deficiency on the Cadillac. He should have gotten credit for that too, because it was under the same concept or the same general nebulous statement that, well, you know, he has been paying support, she's been paying support, so therefore she can keep it. You should have received the credit for both those items. Back to your, I guess something that someone else argued earlier about this underemployment issue. Paragraph 14 of the magistrate's decision, there's a specific finding of fact that says, husband left his employment with Frankie and Dillon's because he believed he could do better on his own. So there was an affirmative finding by the fact there was no shell game, there was no hanky-panky. The court adopted the fact that he left his job because he thought he could do better. In other words, he thought he could do better, and wouldn't that be in the best interest of the children? There's also testimony that he thought he could spend more time. There's some testimony in the record that wife was unhappy with her job at the law office, and that she also had been complaining about it and was interested if they could generate this own business. And there's some case law that suggests that being able to change your occupation, to spend more time with the children, is indeed in the best interest of the children. That's the one case, I think it's the Missler case, where she goes out and she's a nurse and she gets a new job that's closer to home. And this court said, well, you know, it's actually the best interest of the children. She doesn't have to drive as far, she can be with the children. At paragraph number, with the same line of thinking, at paragraph number 17, the court makes a specific finding of fact where they say that Mr. Horak's decision to strike out on his own may have been a mistake. Okay? So the court makes a finding that, gee, he thought that it was a good idea and that it was a good faith belief that he could do better, but he made a mistake. And doing this retroactive analysis of what your income is penalizing someone for a legitimate mistake. It's just not right. Thank you.
Thank you, counsel. Thank you to both sides for your presentations to the court. The court will take the matter under advisement, issue written opinion that will be sent to both sides, and will release it on the website. Have a good day, gentlemen.